It is 10:29, so I'm going to just make a brief introduction here. Y'all can't see me because I got the camera set up on John Griffin, but I want to make sure everyone who's on so far that you can hear okay. Can everyone hear? You can just nod. You can hear fine. Okay, great. Okay, well, we are, speaking is Katie Riggs Johnson. I'm the Vice President for Advancement, Communications and Marketing at Southwestern, and we are extremely glad to have John Griffin as a part of our team here, and he's agreed to offer some learning opportunities for folks, and it's a good way to sort of dip your toe into estate planning and into the sky too, to build begin to build a relationship with him and get to know him a bit. And so today he's going to cover the 11 most common mistakes. Oh, and I got to grab handouts for you. And I will occasionally share the screen. I'll flip to share the screen. I know Ashley sent out the PowerPoint presentation as well as a PDF document, but I will share the screen for those of you who are viewing online so you can see, and we'll try to follow along. But as you have questions, feel free to use the chat if you're online, and just to let us know you have a question, and then when we get to it, when we get a chance, we'll get to it. In the room, we have with us the Metcalfs and the Pecks, and so we have some folks online joining us: Marilyn Corbin, Harold and Nancy Murray, Mike Farrell, Elizabeth Himberger, Cheryl Rude, and Rebecca Kill so far. And I know we have a few more who are planning to join us. We also had a lot of requests for the recording of this, so we'll all do our best to make sure the recording is good and we ask good questions on their behalf. So with that, I'm going to go ahead and let John get started. I'm going to go grab the handouts for you here in the room.
So if you're going to record this, I got to read about a 15-minute disclaimer into it. I'm kidding.
Okay.
All right. So Mike Farrell's didn't know this. He's going to do the first 20 minutes of this, and I'll do the rest.
Yeah, right.
So Mike, go ahead and get started. Good luck. I know Mike real well. So let me tell you, spend just a minute on my background because that will be reflective and maybe carry some weight with regard to the advice that I give you folks. I've been doing nothing but estate planning for 33 years in January. So it's 22 years and about 9 or 10 months. And it's all I do. I don't do divorce law. I don't do criminal defense work, that kind of stuff. I'm a one-trick pony. And my little Mennonite wife told me it's the only thing I'm good at. Being a typical guy, I took that as a compliment until I started driving down the road and thinking about it a little bit. But anyway, and so reading everybody, all other lawyers' estate plans and stuff is relatively boring. But occasionally, just occasionally, I come across something that's pretty funny or pretty interesting. And this was a holographic will. This is not in your materials. This is just a precursor. And this lady wrote her own will. She was a Bethel College graduate. I think she was a registered nurse. And so I'm just going to read this to you. Remember, Mennonite lady, very elderly when I met her. And here's page 16 of her will that she wrote herself. It says, when it comes to my diamond rings and other jewelry, there is something I want everyone to know. For a long time, I have worried about how to divide these things up. I want everyone to know that those gifts that are made in the first 22 paragraphs of my will are made because of my affection for each one of you. I realize that the value of one gift may be greater than the value of another, but I want you to know that the sentiment attached to each of these items is the same. And by Jesus, I don't want any arguing about it. I'm not making that up. That was, I just roared when I saw that. So most estate plans are pretty mundane. Couple other things about me. I don't sell any products, no insurance, no securities. I have 2 LLCs. One is my stewardship counseling, where I do work for a whole cadre of different tax-exempt organizations in Kansas, mostly Kansas, one in South Dakota, community foundations, religious foundations, 3 universities, Washburn, Emporia State, Black Hill State up in South Dakota, and I do some work for Sterling and Southwestern College, but a lot of community foundations. I'm a big believer in those. We'll talk about that if we have time. I also have my Griffin law office where I draft documents, but that's only for people that I meet directly in Heston. I don't draft documents for people I meet through charities because it's a concurrent conflict of interest under Rule 1.7, the rules of professional conduct that apply to us lawyers. It's a waivable conflict, but my wife told me at any one time I'm designing around 150 of these around the country, and I'm drafting about 4 or 5. So anything I can design, I can draft. But I don't draft for people I meet through charitable organizations. I just design estate plans or I update plans. So no cost to me ever, as long as I'm meeting with you guys on Southwestern College. I'm not free to Southwestern College, but I'm free to everybody else. So anyway, all right. So anytime you're talking to a wide group, you never know what the sophistication is. There are some people that have no plan, and there's some people that have a pretty good estate plan, or they think a pretty sophisticated plan. And when you teach to the middle, you always get burned on the fringes. So I'm going to start with the very simplest thing. You know, the will. People ask me this all the time that don't have a plan. Trust me, I'll get into some more sophisticated stuff. But a will versus a revocable trust. They are both ways of transferring assets at your death. The will, not at the first death, because most properties in joint tenancy with right of survivorship, or you've named your spouse as the beneficiary of retirement plans or life insurance. There's no probate process at the first death typically, but there is at the surviving spouse's death. Us lawyers are patient. My dad had a PhD in education, and he said probate is the Full Employment Act for us lawyers. And there's some truth to that. If there's another lawyer on here, then I'm probably going to be in trouble with that, but that's kind of the case. So for most of my clients, I prefer the revocable trust as a technique for settling your estate. You don't have to file a separate tax ID number for a revocable trust. Your tax ID number is your social security number. When you die, if you have a joint trust, it's just the social security number for the surviving spouse. It's not until the surviving spouse's death when the trust becomes irrevocable. In South Dakota, we say irrevocable, means the same thing. It becomes irrevocable. Then your successor trustee would have to get a tax ID number for the trust. But there's 3 advantages of the trust. The biggest one is avoidance of probate. So it's doing the trust and then getting your property titled into the name of the trust and continuing to do that as you assimilate assets. That's number 1. The second advantage is it's a more private type of a document. Only the people that need to know it know it. They're called in Kansas qualified beneficiaries. So when you die, your qualified beneficiaries, your children, unless you have a child that's predeceased, and then that child's children in a per stirpes distribution, that's a Latin term, it means by the root or by the branch, that child's children would be qualified beneficiaries. It's not submitted to a probate court because it doesn't have to become a matter of public record like a will does. You have to get it filed with the court within 6 months after you pass away. On a will with a trust, you don't have to do it because it doesn't have to go through the probate process. So personally, I could care less, I'm dead, but my wife doesn't want anybody knowing her business. And a lot of my clients feel that way. And so they like the trust for that reason. So avoidance of probate, privacy. And then the third advantage applies to some people and not others. If you own any out-of-state real estate, oil and gas interests, a deeded timeshare, commercial property, anything outside the state of Kansas, and you die and you have a will, you're probably going to have to do a probate both in Kansas. And when you finish the probate in Kansas, you have to do what's called an ancillary. I've heard other lawyers say ancillary, but I don't think that's right. An ancillary probate in every state that you own real estate. And the out-of-state lawyers are kind of expensive when it comes to that. Nobody's looking over their shoulder. So if you have a trust, my wife and I, for 13 years old, owned a cabin in the Black Hills of South Dakota, which she sold last fall just before interest rates went up, made a fortune on that. So I'm real happy about that. So one investment I've made that's done really well, that was titled in the name of my trust. So if I would have died, my wife and I have our own trust. We did a long time ago, but there wouldn't have been any probate. She wouldn't have had to hire one of my cronies up there from the University of South Dakota Law School to settle the estate up there. So those are the 3 advantages of the revocable trust over the will. There's 2 subsets of people I don't like to do the trust for. Number 1 is the young married couple who just graduated from Southwestern College. They both have degrees in elementary education, and they just got jobs out there in St. Francis. I'd like to use St. Francis as my example. We were talking about them before, and they have more debt than assets, and she just had twins. Well, to spend a few $1,000s in the attorney's office is cost prohibitive for them. So they're better off with wills. It's what I call kind of the starter plan. You can name guardians for your minor children, spend your extra money on level premium term insurance for 20 years or so till you build up your net worth. And, 10 years down the road, maybe you move to a trust. The other group I don't like to do the trust for is my senior friends at Showalter Villa and Kidron Bethel, the 2 retirement homes that I work for in Heston and North Newton. If you got somebody that's rounding third and about ready to slide into home, and you tell them to take that Unruh quarter, that's a good Mennonite name, and title it into this newfangled thing called the trust, they don't feel like they own it anymore. And I don't know how you got your gray hair, sir, but that's how I got mine. And it's trying to teach old dogs new tricks, and I won't do it anymore. At some point, you're too far gone, and we don't go the trust route. We just stick with the wills and suck it up. They try to get everything set up as payable on death or transferable on death to avoid probate. But there's some disadvantage of that. So that's kind of my precursor on trustees. Let me just talk about that. If we go the trust route, you name successor trustees. If you have a will, you name an executor, executrix. In Kansas, we call that person a personal representative who can and should be a good successor trustee. I've got 4 criteria that I've developed. There are no law books, horn books. This is just me having done this forever. These are the 4 qualities of a successor trustee. Number 1, it's got to be somebody you trust to manage your business affairs, because it's all designed to avoid having a judge involved in the process. So trust is number 1. Number 2, they have to have time to be willing to make time to serve. A lot of us have friends that are soccer moms and dads still running around, and we don't have time. Number 3 is logistics. It helps that they live reasonably close by. If you live in Wichita, well, Oklahoma City or Tulsa isn't too far away, but East Coast and West Coast probably is. So trust, time, logistics. The 4th one is the Kenny Rogers song. Where Kenny died 2 years ago, he had that famous song, The Gambler. You got to know when to hold them, know when to fold up your tent, know when to walk away, and know when to run away. A good successor trustee has to have the gamblers, that mantra. They got to know when to serve, but if you're getting Monday morning quarterback by your siblings, you got to be smart enough to resign. Most revocable trusts give you 30 days written notice to resign as trustee to the next successor trustee, or decline to serve from day one. I've done both. I don't have time to talk about those actual situations today, but they don't want to keep serving if they're getting Monday morning quarterback, because that causes what we call in the business now family disharmony. So that's kind of my precursor on that. A couple of other things. The federal estate tax exemption today is $12.92 million. And ever since January 1st of 2011, you can port the predeceasing spouse's DSUEA, the deceased spouse unused exemption amount, to the surviving spouse. So right now we're at 25 million before we have a federal estate tax taxable estate. Now that all sunsets on December 31st of 2025 if Congress doesn't act. So who knows? But that's the deceased spouse unused exemption amount. You can transfer any unused exemption of the predeceasing spouse to the surviving spouse. You just have to fill out a Form 706 estate tax return and do the 2010 C5A election. So you don't have to go do a complete estate tax return, but you have to do a portability return in order to claim that. So very few of my clients have taxable estates anymore. But when it goes back, it'll go back to, if Congress doesn't act, it'll go back to 5 million index for inflation. And I was at a seminar about 3 or 4 months ago. They're saying it'll be somewhere around 7.1 or 7.2 per person. So we're at 14 in a married couple, something like that. So
we should die soon.
I didn't say that. There's other things we can do so you don't have to die soon if you got a tax problem. The gift tax annual exclusion, section 2503B of the Internal Revenue Code, is what you would know as a $10,000 annual exclusion. It's indexed for inflation. It's now $17,000 per person per donee. So you can leave $17,000 to as many people you want to in the world, and your spouse can do the same thing, or you can gift split on a Form 709 gift tax return, and one of you can make those gifts to family members. We tend not to like to give long-term capital gain property that's really appreciated in value. to kids during our lifetime, particularly if we don't have a taxable estate, because the kids take your basis in it. We call that carryover basis. So if they ever sell it, they have to pay a capital gains tax. Kansas about 15% federal and about 5%. So about a 20% tax on the difference between basis and fair market value. Okay. When we die under section 1014, small b, close parens, I notice none of you are writing this down. I mean, we got Monday Night Football tonight, but if you're bored with that, you can check me out on my code section, see if I'm just making this stuff up. Section 1014B, you get a 100% step up in basis as of your date of death, or what's called the alternative valuation date 6 months later. And so when I do these presentations in churches, this is where I say, the meek shall inherit the earth, but when they do it, it'll be with a stepped up basis. So you don't want to typically give long-term capital gain property. If you don't have a taxable estate to your kids during your lifetime, you want to get that stepped up basis. So
the gift tax is $17,000 for 2023.
yes, per person, per donee. So you can give me 17,000, you can give these three each 17,000, and you can double it if your husband agrees to the gift, and I don't think he's going to do that. So give them cash if you have it, no problem with that. But unless you're over 25 million, there's no tax incentive. And the other thing is, if you give it outright to them, I've had this happen before up in Northwest Kansas, where dad had 30 quarters of ground, mom and dad did, and they had potentially a taxable estate, and somebody had convinced them to make gifts to their kids. So they gave $1.5 million worth of farm ground to each of their kids. And they did it because they didn't want their kids to sell it. They wanted them to get hammered if they did. So it was kind of reverse thinking. But what happened? They left it outright to them. And about 3-5 years after they did it, one of the kids got divorced, and the daughter-in-law got half of it. So hang on till you die. You can always change your plan. We can set up estate plan so that those assets are protected from, creditors, lawsuits, bankruptcy, divorce, those kind of things. I do that kind of stuff all the time. If we have a child or a grandchild that's an alcoholic or a drug addict, there's ways of leaving them an inheritance, but not losing those assets some way or another. And so, this guy couldn't meet with me early enough, fast enough, soon enough to get that thing fixed because he got burned. And that's tough for parents to give something like that and then they watch it disappear. Mm-hmm. So this has nothing to do with charitable law, by the way. Most people come to see me, surprise, surprise, not to make a charitable gift, but to make sure their affairs are in order. So, all right. So I'm off my high horse on that. I generally don't like wills, although for certain groups, they're fine. A lot of people will do the joint revocable trust. I think that is my first exhibit. You've got that one up. If we don't have a taxable estate and it's a first marriage, obviously second marriages with a blended family, when they've only been married 3 or 4 or 5 years, and he's got kids from prior, she's got kids from prior, or if they have a prenuptial agreement, it doesn't work as well. But it's just one trust for both spouses if we don't have a tax problem. And with portability at 25 million, or if the law changes, goes back 14 million, if we're under that, it's kind of like owning property in joint tenancy. But the advantage is over joint tenancy with right of survivorship is not only do you avoid probate at the first death, but you avoid it at the second death, the death of its title and name of the trust. And a lot of people do that now. It avoids probate in other states because you just get that vacation home in Corpus Christi, Texas, or whatever, titled in the name of the trust and get it recorded in the county and the state where it's located, and you don't have any probate on that. I do a lot of those. It's a private type of a document, and you can still create that education trust for grandchildren if a child dies out of order, or for children if they're not very old. And you can set up those long-term trusts for the children or grandchildren. Back to the portability, the DSUEA, I want to be clear about one thing. You can transfer the unused federal estate tax exemption of the predeceasing spouse to the surviving spouse, but for whatever reason, Congress does not allow us to transfer the predeceasing spouse's generation skipping transfer tax exemption to the surviving spouse. So if we're setting up long-term trust for the kids and we may have a taxable estate, we may not want to do that. We may want to set it aside so we can allocate the predeceasing spouse's generation skipping transfer tax exemption. And so we can set up long-term trust and we have both exemptions available to us. Or we can do what's called a plan by disclaimer. That's what my wife and I did. Our original plan back when the exemption was 600,000 back in 1996 or so, piece, and we didn't have portability. Well, when I died first, my estate went into this irrevocable trust for my wife, right? Because you have to set it aside to preserve it. Well, now if I got two trusts, and we don't have a taxable estate anymore. The federal government is disappointed with the Griffins that we have been underperformers, underachievers. So at the first death, I just restated both trusts with new terms because I don't want to create new trusts and have to transfer the property to new trusts. So what we do is at the first death, I just rewrote my plan and my wife's plan at the first death. Everything goes to the spouse. But if the spouse disclaims under section 2518 of the code as a surviving spouse, you got 9 months to disclaim after the first spouse's death, then we go back to the predeceasing spouse's trust, which is always the husband's, by the way. I can tell you guys this 73% of the time. And that says create this irrevocable trust. So we have the best of both worlds and we can take a wait and see approach. So at the first death, that would be the other next chart.
On to the next chart. Oh, that's me.
You get what you pay for around here.
Yeah.
Gosh darn it. So that would be at the first death, everything goes to the spouse. But if the spouse disclaims, and you can do a partial disclaimer, if the spouse is incapacitated, your agent under a durable power of attorney can disclaim on your behalf, then it goes into the family trust. So we could wait until the first death to decide what the size of the respective estates are, because they have to be appraised. The predeceasing spouse's estate has to be appraised. We'll know what the law is at the time, and we can take a wait and see approach. And I don't think I'll ever have a taxable estate, but I wasn't paying somebody else to draft it for me. So that's the plan that we have. It all goes to my wife, which after 26 years, I kind of trust her now. She runs the whole household, by the way. But if she disclaims, then it would come down, or if she had creditor problems, or if she'd run over Bradford, Stockton, grandchild on a crosswalk in Wichita, we can set up this irrevocable trust, and those assets are protected. So there's ways of handling that. Let's see. So that's kind of it on the joint trust. I like them, but a lot of them become outdated and the election is kind of complicated. I'm going to read this to you just because I find this interesting. This is what section 2010 C5A says about portability. It states a deceased spousal unused exclusion amount may not be taken into account by a surviving spouse unless the executor of the estate of the deceased spouse files an estate tax return on which such amount is computed and makes an election on such return that such amount may be so taken into account. Such election, once made, shall be irrevocable. No election may be made under the subparagraph that such return is filed after the time prescribed by law, blah, 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 blah. So you got to have a lawyer help you disclaim or help you make the call on that. I think that kind of language is what I call job security. Don't shoot the messenger. And then in a joint trust, one of the big decisions you have to make is at the death or incapacity of the first spouse, do we make our joint trust irrevocable so we have certainty as to the distribution, or do we leave it revocable so the surviving spouse can change it? And I would say most instances in a first marriage, I would always give the surviving spouse the power to make changes to the plan. If we have a kid that's in a car wreck and has brain damage and we can't leave them their inheritance outright, or things change with regard to family dynamics. So most of those we leave revocable. What a lot of lawyers miss is that interim period when one spouse passes away and the surviving spouse becomes incapacitated. When one spouse becomes incapacitated, the other spouse is fine, but not the first spouse isn't deceased, can the non-incapacitated spouse change it? And if you don't have the specific authority to do it, there's a good argument to be made that you can't. And so you get a lot of lawyers forget that interim period when one spouse becomes incapacitated, but most people like that. And if you have second marriages, it doesn't work well because the surviving spouse leaves it, the wife leaves it to her kids. I'm kidding about that. But, the surviving spouse remarries and the assets without a prenuptial agreement, those assets are protected. But the joint trust, we do lots of those. Next step up is the same one that's don't have to change anything in chart number 2 is the marital deduction plan with 2 trusts, or you can do it with 2 wills. Anything you can do with a trust, you can do with a will. There's no tax advantage for either one. Probate's not a tax, it's a cost of dying. And that sets aside in your example on that chart number 2, setting aside the first estate at the first death. That's great. And it protects those assets from something bad happening to the surviving spouse, or the surviving spouse distributing to some new friend or new family. But you don't get a second step up in basis on those assets that are in what I call in the family trust. You don't get a second step up in basis at the surviving spouse's death. That's again why I like the plan by disclaimer. If everything goes to the spouse, you get a step up in basis on the predeceasing assets at the time of their death. That's that section 1014B that none of you wrote down. But then if it goes to the surviving spouse, we get a second step up in basis. So we have no estate tax. We're also eliminating the capital gains tax at the surviving spouse's death. Now, there may be reasons to disclaim because the estate tax is 40% and the capital gains tax is 20%. So you have an interplay between those two taxes. But so we can either restate the trust like my wife and I did and transfer it all to the spouse and probably not ever create that family trust, or the simpler way is what we like to set it aside because we want to avail ourselves of that generation skipping transfer tax exemption that you can't port to the surviving spouse. So we give the surviving spouse a limited general power of appointment over the family trust. What is a general power of appointment? That's found under section 2514 and 2041 of the code. Anything you can give to yourself, your estate, your creditors, or the creditors of your estate is a general power of appointment. And all I have to do is give the surviving spouse one of those powers. And which one do I give? Well, the power for the surviving spouse to appoint that money in that family trust to creditors of their estate. Who's going to do this? Nobody. But if you just give them the power, that causes the family trust to be included in the surviving spouse's estate for estate tax purposes. And therefore, we get a second step up in basis on those assets. So there's two ways of fixing the capital gains problem. One is restating your trust and just giving everything to your spouse. And two is if we already have this revocable trust or this will that creates the irrevocable trust at the first death, we give because of the exemption so high, we give the surviving spouse a general power appointment. You don't give them all those powers, just the one in favor of creditors or their estate. And all you have to do is give them the power, and that causes that family trust to be included in the surviving spouse's estate for estate tax purposes. You get a second step up in basis. So, and then special powers of appointment, a whole nother thing. I love the flexibility on those family trusts, being able to primarily distribute income to the spouse for their health, education, maintenance, and support, the so-called ascertainable standard. But if the spouse doesn't need all the income, we can distribute the income to children or more remote descendants and catch lower marginal income tax brackets. Remember, irrevocable trusts are always on a calendar year, January 1st through December 31st. How many days do we have, Mike Farrell, to get the income out of the trust at the end of the calendar year?
Oh, man, it's been a while, John. Help me out.
Yeah, I know. I thought I was going to hear it. It's 65 days. It's called the 65-day rule. And Mike knew that, he decided to sit on this in spite of the fact that he knew I'd call him. So I appreciate that. You have one guy telling jokes, you got to have a straight guy. So it's 65 days to get the income out. That way, whoever receives the income pays the income tax, because the income tax on irrevocable trust has been very much compressed. Income over about 14,250, 14,500, I'm real close there, is taxed at the 37% bracket. We're married, filing jointly, you got to be north of 600 or 650,000. So generally, we want to get the income out. Why pay the income to the surviving spouse? Because the document says we got to pay the income to the surviving spouse, pay tax and income tax in a higher bracket. If we're going to give it to the kids anyway, let the kids pay for it in their own marginal bracket. So I like a spray power on the income inside that family trust if I have one. You can do the same thing with principal. The next one I have, kind of give me when I got about 5 minutes left. Durable powers of attorney for asset management, healthcare decisions. Everybody needs one of those. On the durable power of attorney for healthcare and the living will, you got to update those every 5 years, because there are some doctors in Kansas that start giving them less weight, and it costs a couple $100 to have that. Generally, you name the same people. For healthcare decisions for your agent that you name, because you're the principal that you create this power. For agents that you name, I don't care where they live. I only have 2 rules. They can't live off the grid without a cell phone. Doctor's got to be able to call them on the phone. Asset management, we generally name different people, and I think the best estate planning lawyers will do 2 separate ones. I don't mind naming a bank in the last position to make business decisions for me, but I don't want a bank making healthcare decisions for me. And so we tend to name 2 sets of, and a lot of times if we name a kid first over here, we can name another kid for healthcare decisions for, so they feel like they're first at something. And there's the kitchen sink approach where, you know, it's 2 pages long and it's that durable power of attorney, which is kind of generally the agent can do everything. Most good estate planning lawyers will have a durable power of attorney that's significantly longer than that. We're very specific about what you can. We'll have the kitchen sink stuff, but we're also very specific about what you can do, particularly with regard to life insurance policies and retirement plans, because that's the one asset that's not owned by your trust. So who manages assets outside the trust are called the agent. Assets that are titled in the name of the trust is the trustee. So, and then a living will. That if you're in a terminal, if you have a terminal condition, it's in Kansas, we call it the Kansas Natural Death Act. It gives the doctors permission to turn the machinery off, but they won't do it without talking to your spouse or your kids first, because the doctor, he or she doesn't want their deposition taken 6 months or a year down the road. And I have a little chart on that on the living will. My wife came up with that. If you're in a, she says when I sit in front of the TV, I'm in a persistent vegetative state. It's the next one after that. So I think she inserted that in there. I didn't see that till I got down here. So that was anyway. What other problems do I see? No provisions for a child or issue of a deceased child. So we'll say, did my children per stirpes? If it's a couple that has young kids, you need to be able to set up an education trust for them so they don't get too much too soon. You know, for most families, we'll give them what's left at 25, but that gives them between 18 and 25 to go get some sort of post-secondary education. On larger estates, sometimes we'll do a tiered distribution, you know, half at 25 or a fourth or a third at 25, and then end loaded the rest at age 30. The other thing you always want to see in your document is the beneficiary, whether it's a child or a grandchild, must request it in writing. Why do we do that? Well, what are the district court judges in Kansas looking for to protect assets? They're looking for an irrevocable trust. This is an irrevocable subtrust that's created under the wills or the revocable trust at the death of the survivor, husband and wife, or surviving spouse. And it's an irrevocable trust, and it's got a spendthrift clause where the beneficiary cannot assign away their future interest in the trust before they actually receive those assets. And that's all the judge needs to protect them. And that protects it from our friend, Mr. Pistotnik, and creditors, and maybe even bankruptcies and certainly divorces. So if a kid's 25 years old, we don't want it coming out automatically, because in the deposition, it's real easy to find out where you're receiving any income or principal from an revocable or irrevocable trust. They got to answer truthfully. Well, what does it come out? Well, it comes out on my 25th birthday. Oh, okay. What's your date of birth? Boom, they got you. And the next day they're in court taking it away from you. So you always want to say request in writing. It's a big deal. And a lot of lawyers don't think about that. This is another one. State plan doesn't address outstanding indebtedness. If one of your kids owes you money, you really have 3 options. One is it's forgiven. 2 is any outstanding indebtedness counts against the beneficiary at the death of the survivor of husband and wife, or if you're, you know, a surviving spouse at the surviving spouse's death. Or I went with a more nuancical one in my document. It counts against the beneficiary if the trustee finds evidence in writing that you intended to get paid back. If they don't find a promissory note, if they don't find a notation on a check register or check stub, or an amortization schedule or something that shows that you are intending to get paid back, then the trustee is to treat it as a gift and move on. But if they find something in writing, then they reduce that child's share proportionately, and we dictate to the trustee what to do. That way they can just say, well, you know, mom and dad said this is how we have to do it. So you detail that ahead of time, and that helps avoid family disharmony. It's a big problem out there. I have lots of horror stories where one kid owes money and everybody knows about it, and they don't pay him back, or they painted the house. This is the last one I was involved in. You know, a month before mom died, it was a little cracker box. You could have gotten a college kid to do that 30 years in a row for $1,000, and they owed $30,000. They said, well, mom forgave it. Well, there was nothing in writing. And so, and there wasn't one of my plans, but I was involved in that afterwards. They didn't have that outstanding indebtedness paragraph, so the trustee didn't know what to do, and it creates problems, and these kids don't talk anymore. So beneficiary designations on retirement plans are very, very important. We don't want to forget about that. For a lot of city slickers, their largest asset is their retirement plan. My best asset is my wife. My largest asset is my retirement plan. I got that turned around at the one time she came to a presentation that I did. I said, my largest asset is my wife. And it just got real quiet in the room. And man, it was a long drive home. We were in Salina, and it takes about 50 minutes to get back. That seemed like 2 hours. Anyway, typically between husband and wife, you'll name each other as in a first marriage anyway. The spouse is the primary beneficiary 100%. And then the contingent beneficiary can either be children, or it can be your trust as a contingent beneficiary. There's advantages and disadvantages to each, which is beyond the scope of this presentation. But you want to make sure that you do have a contingent beneficiary. If you don't have a beneficiary, if you just named your spouse, you don't have a contingent beneficiary, generally that reverts to your estate and has to go through probate. So you want to be real careful about that. So we always look at beneficiary designations. Life insurance, typically, most folks that I meet with, before they've done a whole lot of planning, they've named each other as the primary beneficiary, and then they'll name my children, or they'll list their 2 children or 3 children or 4 children, whatever it is, as the contingent beneficiary. The problem with that is if your spouse predeceases you and one of your children also predeceases you, the default clause on most insurance contracts is it goes to the surviving children, and you just disinherited potentially the grandkids. If you make the, and if even they let you write the words per stirpes or by right of representation in there, and a lot of insurance companies won't, then potentially grandkids get too much too soon. I don't want to turn a big check over to them at age 18. That's a disaster. So I like the trust to be at least the secondary beneficiary. A lot of times I just make, whether you die first or between a married couple, you die second, I just make the primary beneficiary the joint trust or your own trust. And then the contingent beneficiary, I just write none. Unless you revoke your trust, you don't ever need a contingent beneficiary. It'll flow right on down into that education trust. If it's the kids and they're old enough, they get it outright. But we've got, in a 25-page trust document, we've covered all those what ifs if somebody dies out of order, and they don't give you room to do that on the 2 or 3 lines on a beneficiary designation form. So we like to clean that up. And obviously naming the estate as a beneficiary, not having a beneficiary, that just automatically means probate. So problems with joint tenancy, how am I doing for time?
You've got about 22 minutes.
Okay.
If we're going to the full hour, which there may be some folks on here that need to.
If somebody has a question, they
Yeah.
want to ask me a question, and I can promise you, I've done this a couple of times before. I might be able to get back on track. So
Okay.
if you just want to,
Yep.
because if somebody has a question, probably 4 or 5 people have the same question. So
Yeah.
I'm happy to answer that. So the problems with joint tenancy, I don't have a big problem with joint tenancy between husband and wife. Joint tenancy with right of survivorship, it says JTWROS on it. And checking accounts, particularly if you can make it payable on death to the trust, if the a bank will allow you to do that with CDs, money markets, checking and savings accounts. Obviously, if it's a checking account owned by the entity, then if you have a trust, you move the entity into the trust, and so all the underlying assets are also transferred in there. But I don't like joint tenancy between parent and child, because as soon as you do that, you've made a gift to the child because they provided no consideration for it. That's number one. And number two, if the kid gets divorced, a good lawyer representing the in-law is going to make a play for those assets because technically the kid owns half of it. So I don't like that. Keep it in your own name, run it through the trust. We'll cover those what ifs if somebody dies out of order. And if it's in joint tenancy and the child predeceases, you don't get to change this right back in your estate and has to go through probate. So, but a joint tenancy between parent and child is a disaster. I also don't like, and I know there's financial advisors out there and other people that say this is fine, I don't like POD or TOD to the kids. Same problem. It works great. It avoids probate if everybody agrees to die in the right order. If a child predeceases and mom or dad are incapacitated, and they survive that child, it's right back in the estate and has to go through probate. So POD or TOD to your revocable trust, not a problem. It avoids probate without a beneficiary designated. The POD or TOD to kids or grandchildren, it works if you pray real hard and everybody dies in the right order.
Hey, John, you might mention what POD and TOD are, just in case.
Well, I was going to leave that to you.
No, you do it.
POD just means payable on death, and TOD is transferable on death. Most financial assets are payable on death. Vehicles and real estate are TOD. Don't ask me why one's one and the other's the other. You just kind of have to know that. But again, POD or TOD to a revocable trust make a world of sense to me. POD or TOD to the kids. I'd much rather do a revocable trust up front and get it done. And I have had a couple instances where banks have lost payable on death designations because they changed hands 2 or 3 times. And they said, well, we don't have a beneficiary designated. And so the child as trustee is going through an unnecessary probate. And so if you do things POD or TOD with the bank, make sure they give you a copy of that. If you put it in the trust right away, the monthly statement from the bank every month, it reflects the fact that the bank knows that the account is owned by the trust. It's real hard for them to back up on that 5 years down the road. So anyway, no provisions for a special needs child or kids that have alcohol and drug problems. I come across this all the time. How do I handle them? Well, my wife and I had a child passed away last year. He was severely disabled. He had cerebral palsy. We had set up a special needs trust for him. If you leave assets to a child that has a disability and you leave it the wrong way, either in a support trust or outright to them, the state of Kansas will come running in. The Department of Children and Families, formerly SRS, will require them to spend it down, their inheritance down to about $2,000. If you leave it to them in a support trust where it's distributions are made for their health, education, maintenance, and support, same thing. You have to leave it in a separate trust that's totally discretionary. Sometimes they're referred to as supplemental needs trust, but it's the same thing. And what we do is we bar the trustee, meaning we tell the trustee you are not allowed to make distributions for anything that's covered by a government program for which the beneficiary is eligible to receive benefits. But you can make distributions for everything else. And there's all kinds of crazy things that are not covered by these government programs. Anything recreational, never covered. Repair of a wheelchair, I found, not covered. Dental stuff, not covered. Had a kid fall over, trip over one of those, whatever those things are called in the parking lot, and knocked out his front teeth. Well, parents were alive and they could pay for it because Medicaid wouldn't pay for it, even though he was an adult. So that was the reason they came in to see me. Well, we can cover it while we're alive, but what do we do when we're dead? We don't want that to be the responsibility of our other kids. So we set up a special needs trust for them. And the very best estate planning lawyers, and I think I'm pretty good, but what the very best estate planning lawyers do is they'll set up a contingent special needs trust, because you never know when mom and dad or the survivor of mom and dad are incapacitated but not deceased, and one of the kids is in a car wreck and has brain damage. Well, you don't want to leave their inheritance outright to them. So we can always set up a special needs trust, even though we don't have somebody that's disabled right now. That's really advanced thinking. And that's the separator between the general practitioners doing this stuff and lawyers that are doing it all the time, every day, all day long. We don't have a life. We have our little Hewlett Packard calculator. For me, it's just a Casio because I work for charities. And we got pocket protector, and we're boring as heck. The trial lawyers walk in and they've got big stories and they're real flamboyant and all that kind of stuff. But it is what it is. So, but special needs trust. What do I do if I have a kid that's an alcoholic or a drug addict or a grandchild or something like that? Well, you got to leave their inheritance to them in a trust, because otherwise you become an enabler after you die. I did my first 3.5 to 4 years as a prosecutor in Rapid City. I learned about drug and alcohol abuse. And if you leave an inheritance outright to a kid that's got those kind of problems, it doesn't bode well. So we leave it to them in a trust. We have some independent trustee. Usually it's not one of the other family members, because that creates family disharmony. That's where we name the lightning rod the bank, right? So the bank's the trustee, and we tell the bank, you can require this beneficiary to submit to drug or alcohol tests periodically. And if you do, and if they do, or if they fail to submit to a test, or if they fail the test, then you're not to make any distributions to them for the rest of the calendar year. And sometimes I put in an income matching clause to make sure they roll out of bed and get to work. We'll give you $1 out of the trust for every dollar you have from earned income. I've done that for, kids that don't want to work and stuff. So there's lots of things you can do with this trust, and then you can control where it goes when that child passes away, so you don't become an enabler after you die. No farm or business transition plan in place. I'll spend a few minutes on the farming side of this. If you have a child that's back farming with you, they earn their stripes. So not just they're showing up during harvest, like what my kids and my wife, they blow out there at harvest and spend a couple of days, come back with a couple of handfuls of wheat, and everybody's all excited. I went out there with the idea that I was going to actually do something because I really think I'm a pretty smart guy. I didn't even know how to turn the combine on. And they relegated me. The women were in, I'm stereotyping, but this is true. The Mennonite women were in there making lots of food, and they had everybody out in the field. And my job was to take the old pickup truck with the broom handle sticking out the back and drive the food out there and then come right back. And I spent the rest of the afternoon just kind of riding around with the ATV in the yard. And even that, they were nervous about that. We don't know about this lawyer. We don't want him to get injured on our property, So, but for the kid that's come home and earned their stripes to farm with mom and dad, you have to protect them. And I like to add my special farming provision. So we give them the right to lease all the farm ground. I've not done it for longer than 15 years, anywhere between 5 and 15 years. No matter if other kids get farm ground, they have the right to lease it based on standard custom and usage. And if we can't agree on that, then we have, we can get appraisers and stuff involved. Another option is the right of first refusal. If any other kids want to sell their share, they have to offer it back to the child that's farming first. Well, you're not going to get much money if you get the right to farm it for 15 years. It's not going to be fair market value. It'll be something less than that. So that's usually not a problem. And then the hard one is the option to purchase. Do we give the child that's farming the right just to simply buy their siblings out at fair market value, or 90% of fair market value, or 80% of fair market value? And farm down the ground doesn't do any good unless you have machinery. So do we give the machinery to the child that's farming because they hung in there with mom and dad, or do we sell it to them? Do we let them lease it? You got to cover some of those kind of things. And those are the special farming provisions that I've incorporated into estate planning documents. I kind of don't like this kid gets black acre, this kid gets red acre, and this kid gets green acre, because you won't find 3 pieces of property that have the same value ever, because on the combines now you can measure every square yard. I know that from my father-in-law. So instead of doing that, I just say it's divided between the kids. Maybe you don't want to do it equally. Maybe if you have a farm corporation, you give that child more of the corporation or controlling interest, or you recapitalize it in voting and non-voting shares, those kinds of things. But we want to make sure that the rug doesn't get pulled out from underneath them. So I like to have some provisions. It's not hard if you do this all the time. Again, general practice lawyers tend not to do that. But if you've done this for a while, you've been out in Garden City and North Central and Northwest Kansas. Even my own in-laws came to me eventually with a plan. The old heathen Methodists, they came dragging on in, and we need a plan, because I'd done everybody, all their neighbors. I did hairdresser's plan. They'd heard about me, but they weren't coming in. So, and then I told my wife, I said, I'm too close. Are you recording this? I'm going to stop right there. No, I told my wife, I said, I'm too close. I'm an in-law. I should not be. I should not be doing your parents' estate plan. She said, if you don't do their plan, she said, when people start calling for appointments, I'm going to tell them you're too busy. I was at a football game in Hessen. A guy came and said, John, I've been trying to get in to see you, but your wife says you're too busy. I said, what? So she was actually doing that to me. So I bring him in. I spent 8 hours with him, and her sister says, oh, your husband's too close to this. You shouldn't be drafting the documents. And she was right about it. So I sent him to a guy in Wichita after spending. I didn't send him a bill for anything. I didn't dare. So there you go. All right. No protection of inheritance for lineal descendants. That would be my chart number 4. I do this a lot now, particularly with people that are relatively affluent, that are worried about that daughter-in-law or that son-in-law, or there being problems. That's usually the primary one. It's usually not creditor problems, but it's a bad marriage. Instead of leaving an inheritance outright to a kid, let's leave it in a trust for their lifetime. You can make them their own distribution trustee, their own investment trustee. And if somebody files divorce papers, their spouse files divorce papers with them, they just resign as distribution trustee and we let the bank do it for a while. And so they don't own the assets inside the trust, and a judge can't take away something you don't own. So it's darn close to owning it outright, except it's protected from third parties. This is huge. Remember, I talked about up in Northwest Kansas. Now that guy is still giving land to his kids, but it's all going into these long-term trusts. He set them up during his lifetime. Irrevocable trust. That's how you do it. And I've done a lot of these of late for people that need them. And then when a child passes away, it just cascades on down to their kids. We decide, do we give the in-law a right to income? Usually we don't give them right to principal. What happens if a kid wants to buy a vacation home in Colorado because, or South Padre Island or something like that, or Arizona? I guess, is there still water in Arizona? I think it's coming back a little bit. But Arizona, because the winters are too tough up here, well, we don't pull assets out of this trust and go buy the vacation home in Arizona, because then it's an available resource to third-party creditors. We just buy it inside the trust. So the trust owns it. And now it's still protected inside the trust. These are called dynasty trusts, beneficiary controlled generation skipping trust, GST trust. We're not skipping the kids as a generation, but we're skipping the estate tax in future generations. It's a problem, but primarily we're doing it for asset and creditor protection. And the first time I heard this was 15 years ago at a tax conference in Florida. This guy that kind of came up with all these ideas, and he said, well, yeah, I thought this is just for the uber wealthy on the East Coast and the West Coast. So I was thinking about going out and taking a little walk along the beach. And I was just about ready to get up. And he said, if you have clients and your clients are going to leave one of their children $500,000 or more, are they better off inheriting it outright, or are they better off inheriting in one of these trusts? And I thought, shoot, he's right. They're better off inheriting the trust, and it's protected. And when they die, it cascades down to their kids. We can give them a special power of appointment so they can say, I don't know who my mom and dad talked to, but I'm giving it outright to my kids when they're 25, because they're all ministers or something like that. So they have some ability to make changes to it, but it's protected for their lifetime. So you've protected those assets for a whole generation, maybe several generations. And it costs you, $1,500 or so in the attorney's office to do this extra kind of sophisticated planning. Why would people not do that? Anyway, so again, it's not for the faint of heart. It's for lawyers that do this all the time, like me, every day, all day long. They make a world of sense. Chart 5 about charity, I'll just touch on that, and then I can take any questions. What's the best asset if you're predisposed to make a charitable gift at death? It's always retirement plan assets. And the Internal Revenue Code refers to it as IRD, income in respect to decedent. So anything that would cause you, your estate, your spouse, or your kids to pay income tax on, that's the best asset to give away to charity. For most of us, those are retirement plans, but it could be, under certain circumstances, stored crops, because that's an ordinary income asset if you produced it. It could be the gain in a commercial annuity, not the investment in the contract, but the gain is subject to income tax. It could be interest on a contract. There's a lot of things that are IRD, but the example I gave was retirement plans. At the second death, it's the one big asset that kids have to pay income tax on. If a kid's in a 30% tax bracket, they get 70 cents on the dollar. They get 100 cents on the dollar on appreciated stocks, mutual funds, or farm ground. So if we're predisposed to make a gift to charity, we use retirement plan assets, or generally IRD, and we have to tell the trustee in the document to do that. Otherwise, if they make a pro rata distribution of everything, that doesn't make sense. So you tell them, you dictate, to the extent possible, look around for these types of assets and leave them to charity. Most people that do it will do a percentage rather than a dollar amount, because it stays proportionate to what the kids receive, whether the estate grows or shrinks. I raise $100 million a year for these charitable organizations. There's a reason now why they all call me to do this stuff, but almost always it's at the second death, it's a percentage. And I don't know if it's chart 6 or 7, but they're usually running it through some sort of community foundation. It can pass through and like go directly to Southwestern College, or it can stay at the community foundation or religious foundation and put them on the dole system. But you get maximum flexibility. You can change your mind about the charities, the percentage distribution between charities, the purpose for which it goes to a charity, without having to come back to us lawyers for redrafting. I've never understand that aversion to us lawyers. Maybe I do. But anyway, and then the last one I want to share with you is really cool. I think I've got that in my notes here. That was, and I'm allowed to use his name, so I'll tell you this ahead of time. It was an old friend of mine by the name of Herbert Austin. If you guys remember him, Herb's a really good friend of mine. He took me coyote hunting with him and stuff like that. And this was his machinery. This is many years ago. He decided he couldn't get on the tractor anymore, so it was time to move to town, which was difficult for him. Never married, never had any kids. And he came to me, he said, I've got all this farm machinery. And he said, I said, price at $350,000, but my accountant tells me I've depreciated this out. There are some years you could do it in 1 year. Generally, farm machinery is 5, isn't it? 5. It's all depreciated out. And so I'm going to have to pay a recapture tax, the so-called recapture, the depreciation. John, figure something out for me. And so I said, okay. So what we wound up doing, this is a real story. Sometimes I embellish stories a little bit, but not today. We put all of it, we transferred it, we just did it with an assignment. We transferred all the VIN numbers of all his machinery into this charitable trust. It ran for his lifetime, One Life Charitable Remainder Unit Trust, been around since 1968 in the Internal Revenue Code. We transferred it in, and then we had an independent trustee hold the auction and sell it to third-party buyers. So he's not selling himself, the charitable trust is selling it. And the charitable trust pays him income as long as he was alive. And he lived to like 86 or 87. He lived a long time. And then when he died, it terminated and it went to charity. But since it was the charitable trust that was selling it, not him, the charitable trust didn't have to pay the so-called recapture tax. He didn't get an income tax deduction like you would if you put appreciated stocks, mutual funds, or farm ground in. But with the machinery, didn't have to pay the recapture tax. It brought 385 at auction. The recapture was 154. His net would have been 231, but he had the whole 385 paying him 6 or 7. I don't remember what the number was of the value of the trust every year as long as he was alive. And he completely avoided the recap. Now that doesn't work if you got a kid that's farming, they got to get the machinery. But for my farming clients where the kids are bedazzled by the city lights, they've gone to Southwestern College, and they're out doing other things, working for Archer Daniels Midland or something like that, and they're not coming back.
Making real money.
Making real money, yeah. And so it's kind of a neat technique. I want to say this one thing. So I was standing there at this, they put this, table out there, and this guy's writing out a check to the Herb Austin Charitable Remainder Unit Trust. Of course, he didn't even know what that was. He said, he looked at the Herb, he said, Herb Austin Charitable Remainder Unit Trust. He said, Herb, what kind of scam are you running on the government today? He literally said that. I about fell over backwards, but that's actual. I've done it a number of times. Most recently was about 6 months ago, $1.3 million of depreciated farm machinery. We put it in the CRT. It was all depreciated out, and it's paying mom and dad an income for the rest of their lives. So.
And you designate the charity out of that trust.
Yep. And you can change your mind about the charity, even though it's an irrevocable trust.
Okay.
And I've done that before too. So you can be your own trustee after the initial sale.
Mhm.
You can hire a financial advisor because it's cash now to help you with that. You would name successor trustees. If you don't have family members that would serve in that capacity, I'm sure bank trust department would be willing to do it. Some charities would do it. I don't know if Southwestern would or not. And then you can change the charities, the percentage distribution between charities, the purpose for which it goes to a charity. You cannot change the payout. Once you decide, you have to pay at least 5% out to mom and dad. It can't be 4 or less. And there's 5 different types of charitable remainder unit trust. Everybody would fall asleep if I went through the 5 different types. But if you want to do something like that, come back and see me. I've done a bunch of them. I probably do more of those than I do any other type of charitable remainder trust anymore. Because we want to give the farm ground to the kids because they get stepped up basis if we don't have a taxable estate. But the machinery, it was just sitting out there, and you can make additional contributions to it. I had a guy in Oklahoma put a tractor in 1 year, as long as it's a CRUT and not a charitable remainder annuity trust, a CRAT. But with a CRUT, we put a combine or tractor in one year, and then we put a combine in the next year. So you can do that.
Okay.
I put fat cattle in that charitable remainder trust. Write this down. There's a private letter ruling on this. PLR 9473020. I'm going to check that. Because that's the one thing you might look up and you say, well, this guy's just making up stuff. 9413. Did I say 020?
Yeah.
9413020. I call it.
7-3.
What's that?
You should have 7.
Oh, well, I'm getting, you guys are wearing me out. There's so many questions here. I can hardly keep up. 9413020, and then you go PLR, and you ought to be able to pull that up. You can go to legalbitstream.com and just type in the PLR, and I call it the Rawhide Unit Trust. And the cool thing about it is this guy was going to put both crops, stored crops, machinery, this is a PLR from IRS, and fat cattle into the CRT. And of course, IRS is responding to this private letter ruling. And we've done a lot of, there've been prior letter rulings. So that was the first one, 94. And we didn't do it, but we actually did a Herbst thing, I think, before that. But anyway, they said that you cannot continue, IRS said in the private letter, cannot continue to fatten up the cattle inside the CRT. You have to put them on a maintenance diet until you sell them, because that would be unrelated business taxable income. So read the private letter ruling. Well, it'll put you to sleep, but that part of it I thought was really funny. So anyway, so it's not something I'm making up. This has been done. IRS has ruled on this a number of times, and you can't rely on somebody else's private letter ruling, but it gives us a window into the eye of, or the brain of what IRS is thinking. So I've done quite a few of them. Anyway, that concludes my prepared remarks, semi-prepared remarks. If anybody has any questions, as long as it's about estate planning, I'm happy to answer those questions. Does anybody have a question about estate planning in general or anything that I said?
John,
So, John,
clarification, you can put farmland into a CRT?
Yep, put farmland in there too. And if it's sold out of the charitable trust, the same thing happens. You don't have to pay capital gains tax on it. So you avoid all capital gains on sale and reinvestment. And you get a current income tax deduction for the present value of the remainder interest. If I give a quarter of ground to Southwestern College, I get a deduction for the full fair market value. If I take farm ground and I put it in a CRT where Southwestern College is the remainder beneficiary after me and my wife pass away, I get a deduction, but I get a deduction for the present value of the remainder interest based on my age and my life expectancy under the government's actuarial tables under section 7520 of the code. So it's not the same amount, but you still get a charitable deduction to use to offset income from other sources. So yeah, it's different than machinery. And of late, I've done more of these things with farm machinery, and it means more when you actually use a real person. And Herb told me before he died, I could use his name on all the stuff. He didn't care. He loved it. He was a shrewd, smart guy. Yeah.
So
And
John,
no heirs. No heirs.
No lineal descendants, yeah. So bulk of his estate went to charitable organizations. And that was one where he insisted on me serving as trustee for him. And I really didn't want to do that. But he said, I'm not going to do my plan unless you serve as trustee. I think generally lawyers and accountants should not serve as trustee. You don't need that kind of horsepower. Most of it's ministerial in nature. But he insisted on it, so I did it. It was a lot of work. I mean, he had an auction of his farm ground and all that kind of stuff. I tried to talk him out of that and leave some of it to, give a sweetheart deal to some of his relatives that were farming, but he was very adamant about that. So anyway,
so my question is just, why don't you outline the process by which, if somebody decides they want to review their existing estate plan or they want to get help draft estate plan, what does that look like with you?
Yeah, so they can make an appointment with you because you control my time, and I'm here one day a month, and I'll just sit down and talk to you. If you want to do it by Zoom from your own home, I can do that too. Then I'm not driving down here. But if you want to meet with me in person, that's fine. I prefer, of course, the Zoom. And I'll send me a copy of your trust or your will so I know what I'm starting with, and I'll critique it. I'll see if it's up to date based on all the latest changes and that kind of stuff. If you're willing to send me your financial stuff, I don't share that with these guys at the college, but I need to know what your net worth is because that'll help me give you advice on what the way your plan should read vis-a-vis what the exemption is and that kind of stuff that's going on. My wife sees your stuff. She's a registered dietitian with a master's in public health. I'd give her the title of paralegal, but she wants more money, so I haven't done that. Anyway, and so I just take a look at it, and if there were changes, I can write those down in legalese. I'll work with your lawyer if you have one. If you don't, I still have about 3 people left that are really, really skilled and not too proud of their work, estate planning lawyers. And I do lots of plans with them. And my one rule is we keep the costs down. I mean, lawyers, I'm, getting so proud of the work. A joint trust in Wichita now done by one of the big firms is $5,000 to $6,000. And to have my cronies in my competition, I'll say, close to where I live, they're at $4,500. But a joint trust is fairly simple. I'm getting it done. If I do all the design work ahead of time and it's a lawyer, they'll give you credit for all that pre-work, $2,200, $2,300. So we're saving half or more. And we still get the same. We get a customized plan. You've had time over the course of 2 or 3 meetings to make these decisions. I'll tell you what all your options are. And then I write it down in legalese, and then we send it off to the drafting lawyer. And then they'll send me a copy, they'll send you a copy, and I'll sit down one more time to go over the documents to make sure they say what the 3 of us wanted to say. You're not obligated to Southwestern College or any other charity. I will not work for a charity that requires me to be a fundraiser first. I'm an estate planning tax lawyer first. I'm a fundraiser, a distant second or third, but I look after mom and dad, then the survivor mom and dad, and then the kids and grandkids if necessary. If you want to do something charitable, I'll figure out the most efficient way to do it, and we'll incorporate it into the document. And if you don't, that's okay. Each one of these organizations take their chances.
So appointments with you need to go through Katie.
Yeah.
So that we aren't charged for your time.
Yeah.
Is that what you're saying?
Good point.
That's right. But you're writing that one down. You want a highlighter pen to highlight that? I don't know if you know anything or not, John, but we just want to know you're free. We don't even care if you're any good, but if you're free, that's the most important thing.
That's it.
That's funny. I like that. That's good.
Well,
Yeah, and I will say generally we're working with a schedule where John's here within the first 2 weeks of the month. So it's usually early in the month.
We try to do it the same time every month.
So the next time he's going to be here, for instance, is December 8th. So,
but you do meet with us on Zoom. I mean,
I'm
you could,
happy to do
you could,
that.
yeah, you could. We try to get them in here so we can see our folks. We like to see our folks,
Sure.
and be able to. I like to be able to offer you coffee and say, "How are you doing?" And so that's why we like to have him here, and we like if it's easy for you. Of course, we've got people all over
Yeah.
who would benefit from some time with John, and so in some cases it doesn't make sense for them to come here in office, and that in those moments, a Zoom or a Teams meeting is an easy way to get it done. So those options exist, and we want to accommodate whatever's best for folks.
I'll design a plan in any state except Louisiana. You know why not Louisiana? Because the other 49 states all follow some version of English common law. You have community property states and separate property states. The closest community property state is Texas. Things are a little bit different there, but Louisiana follows the Napoleonic Code. And I could never get anything done there. I had a guy that bought a gas lease, a working interest in a gas well in La Farouche Parish, Louisiana. And we could never get it transferred to the trust. Now I called 2 weeks before Mardi Gras. I figured that, but I called about 5 often. I never got anybody to get back with me on that. So, but other states, I mean, particularly with some of these universities and stuff, and to the extent sometimes colleges, they're living in different states. I just do Zoom calls with them, and they have to find their own lawyer. In South Central Kansas, I know where the players are. I don't know in Southern California, but there's ways of figuring that out. And so, yeah, I do these all over the country.
Do you have any special recommendations on transferring mineral ownership?
Yeah, well, of course, Kansas law says that the minerals run with the land unless they're separated out.
Okay, well, out west where ours are, they have been separated out.
Mm-hmm.
And so therefore, we have minerals underneath property that's probably not our property. I
Mhm.
mean, but it is transferable.
Yep.
I mean,
Yep.
and the problem
That's
is,
separate
of course,
deed to
it gets split every time it's transferred, so it's less and less and less. But at the same time, I've told my children, I said, hang on to those. You never know when they're going to come back in and drill again or whatever, to increase production.
First off, you want to have them owned by your trust, right?
Okay.
And
all
then
right,
secondarily, how many kids you got?
2.
So assuming you haven't fallen out with one or both of your kids, I assume that's not the case because you're smiling. The people that come in are growling are the ones that have a problem with their kids, but it's just another asset and it has to be valued at the time of the death of the survivor, the two of you. And some kids want oil and gas interests and some of them want cash and some of them want farm ground.
Mhm.
So unless there's an overarching reason that the minerals are divided equally between the kids, I just say at the death of the survivor, the two of you, then your estate is divided 50-50 between your two kids. And the trustee, let's say it's a third party, the trustee brings your two kids in and said, what do you want? Do you want farm ground? Do you want cash? Do you want marketable securities? I'm going to try to make this work instead of dictating ahead of time and tying the hands of the trustee. That's where I was back talking about black acre, green acre, and red acre. I've had farmers and ranchers sitting on their tractor for 20 years trying to figure out how to make this fair. And they've got all divvied up, but it's never going to be exactly equal. And some kids want farm ground now, but when you die, they may not. So if one kid's farming and, or they're living on a 10-acre plot, then that's the house and what in the old English common law, they call the curtilage, on that little 5 or 10 acres. Well, we might add some precatory language, that's advisory language, to the extent possible as part of this child's share of their inheritance. We'd like them to get, the rest of the quarter, something like that.
Mhm.
But if there's not an overarching reason to give a kid a certain asset, I just say it's divided between the children. It makes it much easier to divvy it up. And then we can talk to them at that time about, what they want. And then it's the trustee's job to make it equal.
Okay.
But yeah, they're an asset. We just got to get them transferred to the trust.
Yeah.
Right now, my wife, at this very moment, I had a client pass away, and she didn't tell me about all of her oil and gas interests. She told me about the ones in Kansas, not the one in Texas.
Mhm.
And so we're trying to not have to go through a probate in Kansas and one in Texas. You can do this, whatever it is, identity of heirship or something down in Texas. Declaration of heirship, I forgot what it is, but it's a special law down there. But we're having to learn Texas law. I wouldn't have agreed to help settle the estate if I'd known they had all those things down there. You need to get those transferred in. Probably most people are best off hiring Texas or Oklahoma counsel for that.
Well, in Oklahoma, you have to
You
have
have to.
local to.
Affidavit of heirship, that's what it was in Texas.
Okay, well, in
Yeah.
Oklahoma, I had to hire a lawyer in order to sell.
Did you say
property.
lawyer or liar? Come on. Thank you very much for that. You get the B plan. I'm kidding. Go ahead.
Well, whichever.
You had to have one.
Yeah,
Ted said it's Oklahoma's retirement plan for their lawyers.
yeah, oh, yeah.
But you have to hire an Oklahoma law
Mhm.
attorney just to sell one piece of property.
Yeah, I
And-
believe it.
Yeah, and it was,
But get it done, you get it transferred to the trust, there shouldn't be a probate on it then.
yeah,
So
right.
you need to do that while you're alive. It makes it a lot easier for your kids and everybody else.
Yeah, we still have some ownership in Oklahoma.
Oh, I know. I mean,
It
you
was my
cross.
dad's, but he passed away first. Then we thought it went to my mom. We tried to get it transferred there.
Yeah.
Then she passed away before we got it done. So now it's a mess because we
Yeah.
needed to do a probate twice.
Yeah,
Yeah,
yeah.
just like I said, yeah.
We just kind of signed it over and said,
Mhm.
deal with it. Yeah, my aunt has some ownership in that, so
Yeah.
hopefully we can just add it to her.
Yeah, well, and of course, there's some minerals involved in this piece of property we were trying to
Yeah.
sell. We've held the minerals. My sister-in-law and I were doing this.
A lot of people keep
because-
the minerals and sell the surface rights.
Oh, yeah, that happens all the time out where we are, yeah. But this thing, when you cross that state line, you're dealing in a whole different world. And you've about got to hire yourself a lawyer there. Well, you don't have a choice in Oklahoma.
Yeah.
Yeah, so you've got to hire a lawyer.
So we sent this thing down there. I told the guy, if this thing doesn't work in Texas, you've got to hire Texas counsel, but we're trying to do an affidavit of heirship. And
Okay,
it's a pretty simple plan. And you just fill out this paperwork. And we found one that some lawyer had done in Arizona for the same type of property. And so we're just kind of holding our breath and seeing if it works. And you have to have a witness that knew this person. And
I'm going to
it's
send
simple.
you
There's
my
like-
brother-in-law because he's got all kinds of property in Texas that we're going to go through and estate with him. I'm probably that it's just going to be horrendous.
Yeah, it's a lot of work. And it's really people that need to be oil and gas specialists that know something about
Yeah.
estate planning. You
How
gotta,
do you get that appropriate? How do you get it evaluated properly? How do you go get an appraisal done on oil and gas?
well, what I would do is I'd go to that same lawyer that's doing that kind of work and say, who do you use to get qualified appraisals on these things? And
Okay.
they'll know, they'll give you 2 or 3 different names. And then,
Yeah, because I think they're pretty hard to find.
if you don't have a taxable estate, you can, I forget what it is. There's some rules of thumb in these, if it's oil or if it's gas, it's 10 times annual, 4 times annual. There's some rules of thumbs in the, and so they can kind of do that.
Yeah,
One, if you don't have a taxable estate, one of the things I always look for when I'm designing or drafting a estate plan, who are the possible plaintiffs out there that might sue me?
yeah.
Well, will it be IRS? If you don't have an estate taxable estate, they don't care, right? Is it going to be the kids? Well, maybe, maybe not, probably not. Is it going to be some other third party that's going to sue me? And so you always look at that. But if you don't have a taxable estate, IRS doesn't care because they don't get anything out of it anyway. So, you come up with what you think it's worth. And if you want to have a qualified appraisal, that's one thing. If it's not very much, you don't have anywhere close to a taxable estate, maybe you just go with the rule of thumb in the area. So.
Mhm. Okay.
But I have to say, as a lawyer, you have to get a qualified appraisal because I'm on the record here. Any other questions?
Any questions from our folks online? And feel free to unmute yourself if you'd like to ask yourself, or if you would prefer to go through chat, I'll read your question.
Well, let me just say this. John helped me and my wife with our plan. And one of the things that he talked about that's very, very true is that he designed the plan. We took it to our local attorney almost in perfect form. It saved us half of what it would have cost if we'd have gone to our local attorney without going through John. So that was a big benefit to us, and it helped us. First and foremost, it helped us, it helped our family, and it helped us in the most tax-wise, economical manner possible regarding the charities that we're supporting through our estate plan. With that, John, I'll shut up, okay?
Well, and your $5 is in the mail.
Okay, thanks.
We do have trusts set up by an attorney in Wichita, Dan Kerr. I don't know whether you know that.
I know him.
Mhm.
You probably do.
And
So we don't keep it up necessarily
Yeah.
that well,
It's-
but
how often do you really need to come in and update a trust?
The answer is every 3 to 5 years.
3 to 5
Anytime there's
years.
a major change in circumstance. So if you
Yeah.
have a child that dies out of order, you got to get on your plan and look at it. Otherwise, every 5 years. At a minimum, we update the durable powers of attorney for healthcare and living will. I think I mentioned that every 5 years because some doctors give them less weight. But
Mhm.
laws are changing and we can simplify a lot of these plans. That's what I'm finding. Instead of making it more complicated, we're making them simpler now.
Okay, that's good to know.
Yeah, because my wife and I had the 2 trust plan that set aside that first estate at the first death. Well, we don't need that anymore.
Mhm.
I just said everything goes to her. And, her old plan said everything went to me. She just didn't know that. But if I die first, it went into an irrevocable trust, including the golf cart. And I said, I don't want him to get everything. And she said, well, he's left-handed, so he won't use your clubs anyway. So. Yeah, kidding. Yeah, very often we can simplify it, and that now those techniques that we have to avoid capital gains are so important. It's worth having me take a look at it and tell you what I think. Dan Pierce is a good estate planning lawyer, but it doesn't hurt to have somebody take a look at that. I'd be happy to do it. And I'll bet you I can find something to talk about because it's what I do. So.
Yeah, well, and of course, we use an Edwards Jones agent, which sometimes I question what he's doing with our money.
I'm not a financial advisor. I tell people, because people will give me some financial advice. I say, well, I'll tell you what I bought, because everything I bought went south, except for that cabin in South Dakota. But you should keep us in our own lanes. Estate planning lawyers should give you estate planning advice. Financial advisors should give you financial advice. And insurance people should give you insurance advice. And accountants should give you accounting advice. And if there's one that should be overseeing all of it, it should be the estate planning lawyer. So
our problem is our lawyers out where we live that know about our properties and the transfer from one generation to another in our families have all died or else they're retired.
Yeah.
And we've got.
At one time, Hugoton had 10 attorneys.
Yeah.
Oil and gas.
But oil and gas primarily, and
I'm sure.
estates.
I believe that.
And
Yeah.
now they have 2,
Maybe two. And we know one of them, he's done some work for us and he didn't do it right. So we know he's off the record. We won't use him again. So there we are. We don't know the other attorney at all, do we?
No.
So we're kind of in a fix, and Liberal's the same way. We had a really fine lawyer in Liberal. Now his son's in there. We don't trust him at all. So there we go. It's hard to out west. It's really
Well, and
hard.
I remember we talked about North Central and Northwest Kansas.
Yes.
Anytime you get out in the hinterland.
Yeah.
The best estate planning lawyers, as a general rule, there's some outliers out there, but the best ones are usually in the bigger cities and bigger firms because they can specialize. If you're in a small town, it's really hard to do that because you're getting pulled so many different directions. And that's not a mark against general practice. They just can't specialize because you got so many people coming at them with different things and there's nobody else. So.
Yeah, it's just like medical care.
Yeah.
Your primary physicians, are doing it all out there. As that's why they ship everybody back here. If it's any place above their level of expertise at all, you're on the plane, to Wichita. So the best thing you can do is buy that insurance, buy.
Yeah. There you go. Every December.
Yeah. Of course, they're in farming, so are we, and it's a challenge to figure out how on earth to handle how you get everything equally and fairly.
Well, and especially when the
divided.
kids don't want to be in the farm.
Yes.
industry.
Well, ours are out of it totally, so we've got the land leased, and now we've got to figure out, okay, what's the next step here? How do we take care of this and keep that trust current?
And
Up
the
to date.
grandkids are in Timbuktu.
Yeah.
Actually, one of them
Literally.
is in Australia, right?
Yeah. And but this question of protecting from potential divorce is really
Yeah.
primary
real.
when we
It's
set
real,
up that trust. And it wasn't,
And it may not be.
Yeah.
But why not
Yeah.
spend a little bit of money and know
Yeah.
that when it goes to the next generation, all
Yeah.
this hard-earned
yes.
farm ground and assets that you have, it's
Yeah.
not going to wind up disappearing out the side door. So I
Yeah.
do a lot of those kinds of plans
Mhm.
and they make a world of sense. And it's if you think about it, it's the cheapest insurance you ever bought because you only have to pay for it once. And once you got it, you got it. Right? It's not like insurance you have to pay every year.
Yeah.
It works. So
And it's not that we don't love and trust our in-laws. It's just for all practical purposes, when you have a farm as your major assets, then that still needs to be protected in the sense of passing it on, so, yeah.
yeah, so I'd be happy to take a look at it, tell you what I think. And if it doesn't have the long-term trust in it, we can get those established. Makes a world of sense for most folks.
Okay, and then updating the person who determines your health care, that you said.
I do all of that.
Okay.
Yeah, when we do one thing, we do everything. I mean, we look at everything,
Yeah.
but generally, the big thing is looking at the trust or the will and seeing what it says and then updating it so it's current.
Mhm.
All of us in the room here and everybody on Zoom, one of us has to know what's going on, and that's usually me. And as you make decisions, I tell you what your options are. I'll write it down in legalese, and so it's a very efficient process.
Okay.
So,
Okay.
and I've been doing it forever. Like my wife said, is one thing I'm good at, so she's right about that.
Okay, well, I thank you for your
Yeah,
time. It's
thank you
been
so
very
much.
interesting and yeah, we've got to make sure our plans are good,
Yeah.
because we're at.
Well,
grade
you spend a lifetime putting these resources together.
Yeah.
And so many people, 50, I didn't say this, but 50% of the adult population in the United States have no will, no trust. They have the do nothing plan. They got no plan.
Mhm,
And it's just crazy.
mhm.
So you got to spend a little time figuring out how you're going to get rid of it in an efficient manner. And that's what you're talking about.
Yeah.
So,
Yeah.
With the laws that are in place at this time.
Yes. Yeah.
That's a
That's a big
things
thing,
change.
everything's a rover,
yeah,
but even Congress anymore, you just never know what they're.
you never know. I'm not sure they'll do anything
Yeah, I don't know.
before December 31st
I
of
don't, not
2021.
now, not the way they are.
But again, so I tell people, okay, so if you're under 14 million, it doesn't make any difference anyway. Yeah. And so you just make, you make gifts to your kids if you have to, if you're getting close to that taxable thing, or we put undivided interest of farm ground if we have 2 trusts in each trust, because IRS will allow a 5% or so adjustment down in value. They don't like to use the word discount, but adjustment in value by 5% if you own an undivided 1/2 interest. So that's an easy thing to do. And then you can always create family limited partnerships and gift away the limited partnership units and hang on to the general part. There's a lot of things to do if you have a taxable estate. But the nice thing about a big exemption is it's simplified the estate planning. We were doing all these kind of fancy things to minimize value, and so the estate tax was eliminated or reduced significantly, and now most people don't have a tax problem. So then it's what's concern number 2 is capital gains tax. So we focus on that, and I've been doing a lot of that.
Mhm.
So.
Yeah.
All right, well, we've been going here for about an hour and a half, which I'm really grateful to John, and but I think it is just a good reminder that if you have these kinds of questions, you can even schedule a time to talk with John just about those kinds of questions. You don't even have to do a formal review. He's a great resource. And like I said, he's here with us each month at the college. And so want to make sure the invitation stands. And if you are interested in learning more about how to set up a meeting with John, reach out to me, Katie Riggs Johnson. I'm happy to help. I want to also let you know our next coffee chat is going to be with Dr. Pat Ross, and he's going to be talking about the honors program here at Southwestern College, which is in its inaugural cohort. So we're going to do that on December 8th. It'll be at 10:30. And so this is going to be a regular series and just explore the little nooks and crannies of Southwestern, and hopefully people can be updated, and we'll record all these sessions and make them available as requested. So if you're interested in participating in that, you can simply email alumni@secans.edu, and we'll make sure you get the link and you're in the loop. But Dr. Ross is an incredibly entertaining guy, and it'll be really interesting. He's been really doing a lot with this first cohort of honor students, and it's been really impressive to watch. So we're anxious to share that with you. So again, if you're interested in meeting with John, just let us know, and we'll get you set up. And we're really grateful for you all taking the time, and go Builders. So, all right. Thank you all so much, and we'll let you go for the day. Thanks.
Thanks, Katie.